Hallo und herzlich willkommen zu WeltRechtlich, dem Podcast des Internationalen Forschungs- und Dokumentationszentrums Kriegsverbrecherprozesse an der Philipps-Universität Marburg. Ich bin Henning de Vries und Geschäftsführer des Zentrums. Am 12. Dezember 2024 feierte das ICWC sein 21-jähriges Bestehen. In diesem Zusammenhang fand auch die Marburger Vorlesung zum Völkerstrafrecht statt, zum 15. Mal. Den Vortrag hielt Professor Dr. Sarah Nouwen. Sie ist Professorin für Public International Law am European University Institute in Florenz. Ihr Vortrag trug den Titel The Question of the Political and the Political Question of International Criminal Law. Und der Vortrag wurde auf Englisch gehalten. Sie warf die Frage auf, ob internationale Strafgerichtshöfe politische Fragen lösen können und wenn ja, auch sollen. Dabei hob sie hervor, dass juristische Antworten zwar Impulse setzen können, aber Politik einen weiteren Spielraum als Justiz für Problemlösungen hat. Dies fand ich vor allem für die aktuellen Konflikte überaus spannend und wünsche euch daher ein tolles Hörerlebnis.
Sehr geehrte Damen und Herren, Kollegen, Freunde. Es ist eine sehr große Ehre, dass Sie mich eingeladen haben, heute mit Ihnen zu sein. Wie Sie hören können, und ich entschuldige mich dafür, ist mein Deutsch während meiner langen Zeit in Großbritannien ziemlich eingerostet. Es ist daher im Interesse aller, dass ich jetzt auf Englisch umschalte. Today we celebrate the founding of the International Research and Documentation Center for War Crimes Trials at the Philipps-University. The topicality of such research is a cause of grief. The news that we receive from Sudan, Palestine and Ukraine suggests that war crimes are not exceptional phenomena, but the order of the day. Indeed, while we are here together, men, women and children will be killed or will starve to death due to man-made famine. In the midst of all this undeniable criminality, and indeed criminality in which we may be, through our governments and our spending patterns, complicit, I sometimes wonder whether to give up being an academic and a lawyer and instead become a politician or an activist and at least do something. And yet, one does get the impression that our field of study, criminal law, and in my case specifically international criminal law and international law more generally, at least provides a language and venues to say, no, this is not allowed to be the order of today. And in response to attempts by militaries to expand their license to kill under humanitarian law, no, these remain violations of international rules and do not reflect the rules. Millions across the world look with great expectations to The Hague. No, not to the current Dutch government, but to the International Court of Justice, moving forward in the genocide case that South Africa brought against Israel, and to the International Criminal Court, where arrest warrants have been issued, as was already mentioned, for the President of Russia, his Commissioner for Children's Rights, and 4 military actors, and more recently for the Israeli Prime Minister, the former Defense Minister, and a reportedly already deceased Hamas leader. The prosecutor has also requested an arrest warrant for the acting president and military leader of Myanmar. Beyond the ICC, there have been efforts to create a new tribunal, an aggression tribunal, so that also that crime, especially in the context of Ukraine, can be tried at the international level as long as the jurisdiction of the ICC remains very limited. There's also hope that these decisions at the international courts will shape the outcome in domestic proceedings, for instance, those that were brought to stop arms transfers. It is in this context that I received the invitation to speak to you today. It specified we are particularly interested in the tense relationship between international criminal law and international politics in the current armed conflicts. Wow, this was one of these invitations where you can't just present whatever you'd be working on at this moment. You actually asked me a big meta question, the question of the political in an international law, a criminal law, and perhaps also the political question in international criminal law. And I will try to talk today about these two. So first, I will speak about what I term the question of the political, namely the question whether international criminal law is political. And for that part of the lecture, I will draw on work with Professor Wouter Werner. The second question is how international criminal law engages with the political, and more specifically, the status of the political questions doctrine in international criminal law. I will conclude that while international criminal law is political and has not shied away from engaging with the political, it is important to leave space for politics outside law and courts. The language of law is at least something, but can only provide a narrow set of answers. So there we go, the question of the political and international criminal law. So let's do a little test. Who says here that international criminal law is political? Hands up, please. Who says it's not political? Nobody. Okay, that's and who says it depends? You didn't know that was an option. Okay, next we try with it because lawyers love it depends, right? As an answer. And indeed, it always depends, of course, on one's definition. So let's do a few of those. Is international criminal law political? Well, international criminal law is clearly not political if we define politics as the opposite of law. And this is what the recent High Representative of the EU, Josep Borrell, seemed to mean when he commented on the arrest warrants issued for the Israeli officials. He said, it's not a political decision, it is a decision of a court of justice, of an international court of justice. If, as it seems in this statement, the political is the negative counterpart of law, then law is by definition apolitical. Now, everyone is free to come up with their own definitions, but defining the political as the opposite of the legal does not seem to do justice to either the legal or the political. As Morgenthau has argued, and I quote, the legal and the political are not at all an adequate pair of concepts that could enter into a determinate contrast. The conceptual counterpart of the political is formed by the non-political and not the legal. Now, whereas international criminal law is never political if the legal is defined as the opposite of the political, international criminal law is definitely political if we define the political so broadly that it covers all decision-making and all social interaction. And many critical studies of international law, for instance, show that decisions are the result of human choice rather than prescribed by international criminal laws. And they therefore often argue in critical legal studies, you see, law is political. Now, again, everyone is free to come up with their own definitions, but the problem with such a broad definition is that it has little distinctive value. It submerges all law into the political and leaves the category of the non-political rather empty. So what then are more positive and meaningful definitions of politics? And is international criminal law political in those senses? Now, in one definition, politics is about making agreements among people so that they can live together. The International Criminal Court is in that sense clearly political because it was created pursuant to an agreement, the Rome Statute. The Rome Statute is political, like domestic legislation is political. They are the results of agreements among lawmakers. So the International Criminal Court is thus the enactment of politics. The Rome Statute is also political in another sense, namely in that of politics as the pursuit of the ideals for the polis. Anti-impunity is such a political ideal. The International Criminal Court pursues this political idea, so in that sense, the International Criminal Court enacts politics. Now, international criminal justice is also political if politics is perceived as distinguishing between friends and enemies. I know this is a controversial definition. International criminal law provides a vocabulary with which opponents can label the enemy as a violator of universal norms, and thereby as an enemy of humanity. Adjudicating on genocide, war crimes, aggression, and most notably crimes against humanity, the court brands some people as enemies of mankind, hostes humani generis. At the same time, those who assist or cooperate with the court are elevated on the stage of virtue, as the soldier or policeman, enforcing universally valid norms and fighting humanity's enemies for humanity's sake. This political power explains the initially unexpected but relatively frequent so-called self-referrals, states triggering the International Criminal Court's jurisdiction on their own territory. When the Rome Statute was negotiated, few had expected this. But the states, Democratic Republic of the Congo, Central African Republic, Uganda, Mali, and later Palestine, soon realized the power of the ICC's proceedings against one's political enemy. The domestic political opponent can be transformed into a hostis humani generis, which leads to more international support in the fight against one's enemy. Thus, in all but one of these understandings of the political, the legal and the political are not opposites, but they overlap. Now, Martti Koskiniemi has theorized the dual legal and political nature of phenomena as a competition of vocabularies. The same factual phenomenon can be described in the vocabulary of politics and the vocabulary of law. And he has illustrated this with Wittgenstein's famous duck-rabbit image. One can see both a duck and a rabbit. So my question to you here should not be, is it a duck or is it a rabbit? Or is it legal or is it political? But what are the consequences of seeing it, international criminal law, as a duck or as a rabbit, as legal or as political? Each vocabulary comes with its own expert systems, values, institutional practice, and authority. Thus, when Sudan under President Bashir refused to engage with the ICC in the courtroom and instead focused on the UN Security Council, it refused to adopt the vocabulary of law. Similarly, US President Trump objected to the prosecutor's investigations into torture in Afghanistan, not in the courtroom, but by imposing sanctions on ICC officials, something he has threatened to do again in response to the court's arrest warrants for the Israeli officials. Understanding these reactions as political reactions does not mean justifying those reactions. They can be bad politics. Similarly, saying that the court is political does not mean that it has failed its mandate. In some senses of the term politics, the court has a political mandate. The question for evaluation is whether those politics are worth supporting or not. And the challenge is that it is impossible in the abstract. It requires a case-by-case assessment. It is one thing to analyze whether the work of a court is in and of itself, in some understandings of the word, political. It is another, although a related thing, to assess how the court deals with the political. Now, some national jurisdictions, and here I note not Germany as far as I'm aware, have a political questions doctrine, and sometimes also referred to as the doctrine of non-justiciable disputes, the acte de gouvernement or the atto di governo. Courts can invoke it to avoid pronouncing on issues that, according to the separation of powers, should be addressed by other branches of government, or in case they believe that the judicial process is not adequate for addressing the matter. For instance, a US district court argued earlier this year that a case brought by a Palestinian human rights organization against the US president and other US officials was outside its jurisdiction, as, and I quote, any determination to challenge the decision of the executive branch of government on support of Israel is fraught with serious political questions. End of the case. Does international criminal law know of such a doctrine? In the next part of the talk, I'll argue that the doctrine is only occasionally invoked, and when it is, it's mostly rejected. But exceptionally, it's sustained. However, sometimes we actually see the doctrine appear in other guises. So given how political international criminal law is, it is remarkable how rarely the argument is made, this is political, this international criminal court or tribunal should not deal with this. One reason for the apparent absence of the political questions doctrine in the field of international criminal law may be that the field is following tendencies in the field of international law more generally. This was suggested by the ICWC, the Tribunal for the former Yugoslavia, appeals chamber in the Tadic decision, when it dismissed the political questions doctrine to argue that it could actually review the legality of its own creation by the Security Council. The appeals chamber argued, the doctrine of political questions and non-justiciable disputes are remnants of reservations of sovereignty, national honor, etc., and very old arbitration treaties. They have receded from the horizon of contemporary international law, except for the occasional invocation of the political questions argument before the International Court of Justice in advisory proceedings and very rarely in contentious proceedings as well. The court has consistently rejected this argument as a bar to examining a case. And so did the Tribunal for the former Yugoslavia. Now, the ICTY was right in that the political questions doctrine seems on its way out in public international law. Almost 100 years ago, Hirsch-Lauterpacht wrote a 400-page treatise in which he argued against the then prevalent idea that international courts or tribunals could not address political questions. And now I mentioned the word Hirsch-Lauterpacht, I want to make one intermezzo. I learned today that, Hirsch-Lauterpacht had one son, Ellie Lauterpacht, who died a few years ago. Today, or yesterday, his wife died, Kathy Lauterpacht. Now, she was not a famous international lawyer, Ellie Lauterpacht was, but I just want to pay tribute today to her because I think she has fueled many international lawyers. She was always there providing international lawyers who came to her house with a lot of energy and support. So today, also, not only I want to invoke Hirsch-Lauterpacht, but also Ellie and Kathy. Anyway, Hirsch-Lauterpacht wrote a treatise arguing against the political questions doctrine. Referring to the practice in arbitration treaties, he explained that many authors at the time were of the view that those disputes that affected the independence, honor, and vital interest of the state were political, and therefore non-justiciable. In their view, legal disputes were only those disputes that were unimportant. Now, Lauterpacht rightly pointed out the problem with this terminology. The concepts legal and political were here used in a very different way than in the social sciences, namely merely as each other's opposite. What we in the beginning of this lecture discussed doesn't make a lot of sense. Lauterpacht argued that if the concept of legal disputes was instead interpreted to mean those disputes that can be settled by applying legal rules, it would be evident that even the most political disputes could also be legal disputes, especially because in Lauterpacht's view of international law, there was no non-licet. International law always had an answer. Now, in general international law, this view has prevailed. The International Court of Justice has echoed Lauterpacht in several cases. In contentious cases, it is held that the fact that a dispute has other non-legal aspects does not mean that the court cannot consider it. And the fact that the legal dispute is only one aspect of a political dispute is not a reason for the court to decline deciding on the legal question. And that the resolution of such legal questions may be actually important, sometimes decisive, factors in promoting the peaceful settlement of disputes. The International Court of Justice has adopted the same approach with respect to advisory opinions. Exceptionally, however, individual judges still invoke the political questions doctrine. And a recent example is Judge Julia Sebutinda's dissenting opinion to the order of interim measures on Israel earlier this year, where she argued, I'm strongly of the view that the controversy or dispute between the State of Israel and the people of Palestine is essentially and historically a political or territorial, and I dare say ideological one. The dispute or controversy is not a legal one calling for judicial settlement by the International Court of Justice. Now, she was the only one. But it did make an appearance. More importantly, perhaps, variations of the political questions doctrine continue to appear before the court, although they're often rejected. For instance, in the proceedings on the occupation of the Palestinian territories, some states had argued that the court's opinion would undermine negotiations between Israel and Palestine, and that the court therefore should exercise its discretion to refrain from giving an opinion. The court responded by arguing that its opinion would be an additional element in the negotiations, and that the effect of the opinion is a matter of conjecture and disagreement. Another variant of the political questions doctrine is the argument that the court does not have enough factual information, or that the matter is too technical for courts to decide on. An argument that was also invoked in the occupation proceedings, and again dismissed by the court. Now, when in 2020 a few states and amicus curiae invoked the political questions doctrine before the ICC, an ICC pre-trial chamber rejected it by adopting the ICJ's arguments against the doctrine. The ICC prosecutor had asked the pre-trial chamber for a ruling on the court's jurisdiction, territorial jurisdiction over Palestine. The question before the court was whether Palestine could be considered, and I quote, the state on the territory of which the conduct in question occurred. Palestine had been admitted as a state party to the ICC, but its status as state in general international law was still contested. And these few states, I should say, a minority, and amicus curiae had argued that the ICC should not go ahead with its proceedings on the ground that it was too political to have to kind of imply whether or not Palestine was a state. Israel, for instance, had asserted that, and I quote, any exercise of territorial jurisdiction by the court would not only require it to make a determination wholly unsuitable for an international criminal tribunal, but would also contravene the Oslo agreements reached between the parties and jeopardize efforts towards reconciliation, unquote. The pretrial responded with the ICJ's arguments that I gave you in the beginning, saying that by their very nature, the facts of international crimes arise from controversial and politically sensitive contexts, and that the judiciary cannot retreat when it is confronted with facts which might have arisen from political situations and/or disputes, but which also trigger legal and juridical issues. It continued that the question at hand is capable of a legal answer, and it also observed that potential consequences that might arise from the present decision are outside of the scope of the Chamber's mandate, and therefore not a bar to jurisdiction. Now, apart from this one instance, the ICC seldom explicitly engages with the political questions doctrine. So while at the ICJ, the doctrine is still sometimes invoked and then dismissed, it seems to appear less in international criminal law. Now, why is that? At first sight, it may seem that the political questions doctrine does not come up because international criminal law concerns individual criminal responsibility rather than state responsibility. Judgment of the individual does not necessarily affect the state. However, in international criminal law, it often does, especially when heads of state or government are the subject of the proceedings. In Sudan and Russia, and possibly Israel too, the ICC's actions have been perceived as regime change by arrest warrant. Another reason for the limited invocation for the political questions doctrine may be that the judicial train has left the political station. Even if its work may in many ways touch upon the political, it was decided at the station, namely the negotiations of the Rome Statute, that would not halt the court once it was established. Everything political would have to be sorted out at the station during the negotiations. Now, at the station, both proponents and opponents to a strong independent international criminal court invoked the risk that the ICC would get entangled in politics. Proponents of a strong independent international criminal court argued against political interference with the court, and therefore opposed, unsuccessfully, the provisions according to which the Security Council has the power to refer a situation to the court, and especially its power to halt ICC proceedings for 1 year renewable. By contrast, they insisted on the prosecutor's powers to open investigations on his or her own motion, precisely the power that the opponents of a strong independent court argued would render the court a political actor. So both sides argued against politics, but one argued against the politics of the Security Council, and the other against the politics of an independent prosecutor. Both apparently saw the act of triggering the court's jurisdiction as a political act. They disagreed as to which actor should be entrusted with this role. Now, in the end, the compromise was, albeit still not acceptable to the US and some other states, that the Security Council can refer and that the prosecutor does have proprio motu powers, but requires judicial permission to proceed with an investigation that they want to open proprio motu. No such permission is required when the Security Council or states refer, suggesting that there is no concern with politics when the politics of the prosecutor and the politics of the Security Council align. During the negotiations of the statute, opponents also argued against inclusion of the crime of aggression in the statute, because this would be too political a crime for the courts to adjudicate. Eventually, the crime was included but not immediately defined. The crime is now defined, but the court's jurisdiction over the crime depends on both the state against which the crime is committed and the state by whose nationals the crime is allegedly committed, being state parties. And this explains why the court cannot exercise its jurisdiction now over crimes of aggression committed by Russian officials against Ukraine. Now, with all these compromises about politically contested issues during the Rome negotiations, it may seem that the political questions doctrine was left at the station and the ICC has moved on without it. And yet, while the political questions doctrine is seldom officially invoked or endorsed, let alone endorsed, we occasionally do see it in international criminal law, albeit sometimes disguised. First, whereas the International Criminal Tribunal for Rwanda and the Special Court for Sierra Leone followed the ICTY appeals chamber in reviewing the legality of their own creation and dismissing the argument that this was too political, the quote I began with, the appeals chamber of the Special Tribunal for Lebanon has abruptly ended this line of case law, arguing that the Security Council's choice of measures was, and I quote, essentially political in nature and as such not amenable to judicial review, and it refused to review the legality of its own creation. A second way in which the political questions doctrine reappears in international criminal law is under the cloak of some provisions in the Rome Statute. In some respects, the political questions doctrine has been legalized. For instance, Article 16 provides that the ICC may not continue or commence with an investigation or prosecution if the UN Security Council acting under Chapter 7 of the UN Charter requests this to defer proceedings, which it can do for maximum 12 months at one time. Here we see the separation of powers doctrine that underpins the doctrine in certain domestic jurisdictions. Article 16 is the states parties of the Rome Statute recognizing that the Security Council has the primacy in matters of international peace and security. Some states and regional organizations have asked the Council to use these Article 16 powers, for instance in the context of the peace negotiations, between the government of Uganda and the Lord's Resistance Army, in the context of Sudan, Libya, and Kenya. But thus far, the Council has never used it in concrete, ongoing proceedings. In addition to the Rome Statute, we can find remnants of the political questions doctrine in the court's own case law. As I mentioned, in its ruling on its jurisdiction in Palestine, the pretrial chamber rejected the political questions doctrine. But it also created an opening for it. The chamber rejected the argument of the political questions doctrine only after noting that arguments to the effect that the aim or consequence of the prosecutor's request would be the creation of a new state reflect a misunderstanding of the actual subject matter of the request. Indeed, the creation of a new state pursuant to international law is a political process of high complexity, far detached from this court's mission. Now, the pre-trial chamber could have left it by saying that because it had determined that Palestine had been admitted as a state party to the Rome Statute, it was also a state for the purposes of Article 12, the basis of the court's jurisdiction, and that it therefore did not need to address the question whether, as a matter of international law, Palestine was a state. This would have been the judicial economy that we scholars often despair of, because we always want to learn more. But it is a justifiable aspect of judicial practice. However, the chamber has here given the political questions doctrine a helping hand by emphasizing that the creation of state is a political process of high complexity far detached from the court's mission. After all, the creation of states, while indeed a hugely political process of high complexity, is also a legal question. And while adjudicating on statehood may not be the ICC's core business, it may come up incidentally, just as so many other legally complex questions of public international law, think immunities, have come up incidentally before international criminal courts and tribunals. Now, finally, there are instances in which court actors do not refer to the political questions doctrine or provisions in the statute that give it effect, but they resort to other strategies to avoid being seen to interfere with politics. Yet Odermatt, studying the Court of Justice of the European Union, the International Court of Justice, and the East African Court of Justice, has noted that international courts are rarely upfront about avoidance strategies. He says, rather, international courts tend to avoid cases in a more subtle fashion, relying on procedural rules to exclude a case, or by resolving a dispute in a way that avoids the most politically sensitive questions and controversies. Now, a prominent example at the International Court of Justice is a hugely formalistic decision that allowed the court to escape deciding on whether the UK, India, and Pakistan had violated international law by not engaging in nuclear disarmament negotiations. According to the court, the Marshall Islands had failed to demonstrate the existence of a dispute between it and the respondents, and therefore the court lacked jurisdiction. Thus far, the court has always managed to dodge deciding cases that had to do with nuclear arms. At international criminal courts and tribunals, we can also observe avoidance strategies. One such strategy is delay, or putting it more positively, giving other actors a chance to address the situation politically or diplomatically, or through domestic courts, and thus a chance successfully to invoke the principle of complementarity. Here, the notable fact is not so much that such strategies are adopted, but when they are and when they are not. This reveals when the court is concerned about diving into politics. For instance, compare the speed of the court's action in Libya with that in Palestine. The Security Council referred the situation in Libya to the ICC in February 2011. The prosecutor opened an investigation in March 2011, and the first arrest warrants, including against the then Libyan head of state, were issued by the 27th of June 2011. In other words, within 4 months after the referral. In the case of Palestine, the government of Palestine recognized the court's jurisdiction for the first time in January 2009. In April 2012, more than 3 years later, the Office of the Prosecutor expressed the view that it could not determine whether Palestine was a state for the purposes of the jurisdictional provisions of the Rome Statute, and that it had to wait for the UN or the ICC Assembly of States Parties to decide this matter. In January 2015, Palestine, by then a non-member observer state at the UN, recognized the court's jurisdiction again. At the same time, Palestine also became a state party to the Rome Statute. In May 2018, Palestine referred the situation in Palestine to the ICC. In December 2019, the prosecutor announced that the criteria for the opening of an investigation had been met. In January 2020, it asked the pretrial chamber to rule on the court's jurisdiction. In March 2021, the prosecutor confirmed the initiation of an investigation. In November 2023, and we know what happened in November or October 2023, several states referred the situation in Palestine to the ICC. In January 2024, even more states did so. After the prosecutor's request for arrest warrants in May 2024, the ICC pre-trial chamber allowed dozens of scholars, NGOs and states to provide amicus curiae briefs, again on the question of jurisdiction. As you know, the first arrest warrants were issued last month, more than 15 years after Palestine's first recognition of the court's jurisdiction. Of course, the differences in speed may be the product of differences in the events in the context of which crimes were committed, and also differences in complexity. But part of that complexity is political sensitivity, which the court addressed in the Palestine situation by allowing states and other actors to make amicus curiae submissions several times during the process, every time again delaying the proceedings with several months, until the political pressure to move was such that further delay was becoming at least as politically risky as deciding to move on. By contrast, in the Libya situation, and with the support of the UN Security Council, the court raced ahead, despite calls from the African Union to give negotiations a chance. Another example of the political questions doctrine in other clause is the interpretation of open-ended terms to avoid political clashes. And one such concept is that of the interest of justice. According to Article 53 of the Rome Statute, the ICC prosecutor may decide not to open an investigation or prosecution where this would not be in the interest of justice. Now, during the negotiations of the Rome Statute, some states believed that the interest of justice would encompass the interest of peace. It was primarily South Africa arguing this. The interest of justice in Article 53 could thus be the prosecutor's version of Article 16. The Security Council could invoke Article 16, the prosecutor could invoke Article 53 when the prosecutor feared that trials would interfere with the peace process. The ICC prosecutor, however, seems to have closed this door by arguing in a policy paper that the interests of justice do not encompass the interest of peace, and that the interests of peace are not its responsibility, but that of the UN Security Council. And yet, the concept made an appearance as an avoidance strategy in 2019, when an ICC pre-trial chamber invoked it as an argument to refuse authorizing the opening of an investigation into Afghanistan. The chamber argued, and I quote, "An investigation can hardly be said to be in the interest of justice if the relevant circumstances are such to make the investigation not feasible and inevitably doomed to failure." Now, what were those relevant circumstances? They were the scarce cooperation that the prosecutor had received and the limited likelihood that the evidence and the suspects might be available and within reach. The chamber here referred to the political landscape in Afghanistan and that of key states, read the United States. The chamber concluded that, notwithstanding the fact all the relevant requirements are met as regards both jurisdiction and admissibility, the current circumstances of the situation in Afghanistan are such as to make the prospects for a successful investigation and prosecution extremely limited, and therefore decided that an investigation into the situation in Afghanistan at that stage would not serve the interest of justice. The chamber thus allowed realpolitik to shape a decision whether to open an investigation through the concept of the interest of justice. The appeals chamber, however, authorized the investigation, deciding that it was not up to the chamber to take into account the interest of justice when the prosecutor didn't raise it. In sum, the political questions doctrine is seldom explicitly invoked before international criminal courts and tribunals, and even less often successful. That said, it occasionally makes an appearance, either through legal concepts in the Rome Statute or in other guises as avoidance strategies. So where are we now today? Final part, promised. We can observe that hugely political questions have been taken to international courts, including international criminal courts. These courts, in turn, have generally embraced this judicialization of politics. At least, they've generally not turned to the political questions doctrine to ward it off. Indeed, in some instances, they have explicitly rejected the doctrine. Following Lauterpacht, they have argued that political disputes also have legal questions and that their role is to settle those legal questions. Or, to put it in Koskiniemi's terms, lawyers have successfully redescribed political questions in legal language, which allows courts to apply their expertise. Now, lawyers are likely to push for more judicialization of politics. As Koskiniemi has argued, these languages of our expertise are in search for hegemony. They look for expansion of their domains of expertise and relevance, leading to a battle of redescription. But there are reasons for caution. The fact that a political issue can be redescribed as a legal question does not mean that the legal answer exhaustively solves the issue. In the context of international criminal law, the ICC will decide on the criminal responsibility of a few individuals. The political aspects of the conflict will continue to exist and also require an answer. Let me take you to 3 places for 3 examples. First, Uganda. The ICC recently concluded the trial of Dominic Ongwen, convicted him of numerous war crimes and crimes against humanity, and sentenced him to 25 years in prison. The legal question that dominated during the trial was whether the fact that Ongwen himself had been abducted at a very young age of 9, made him in any way less responsible for the crimes that he later went on to commit as an adult commander in the very army that he himself had been forced into. The court said no. The question has thus been answered. But other questions have not been answered. Why were many people in the community that had been victimized by the LRA of the view that the government of Uganda was equally guilty? What were they guilty of, and what would be required for that political relationship between Uganda's north and south, a division that has its origins in colonialism, to heal? Secondly, the former Yugoslavia. Reading the decisions of the ICTY, one gets the impression that crimes were committed as part of centuries-old feuds among ethnic groups, committed by nationalist men who raped women as part of their warfare strategies. However, by studying tens of thousands of pages of trial transcripts, Marina Velikovic has observed that many of the witnesses also tried to tell the court another story. A story of the enormous economic downturn after the end of communism and the turn to capitalism, and how economic precarity related to criminality and victimization. The judges did not pick up on these arguments in the testimonies because they did not easily fit within the language of international criminal law. Just like the judges in the Ongwen case did not engage with arguments about the LRA's spiritual world because the spirits were too hard to match with the provisions in the Rome Statute. But both economics and the spiritual world are important realities to conflicts that require engagements. Perhaps not by a criminal court, but a criminal court can never be looked at to provide the answer, or for that matter, the history. Thirdly, South Sudan. Soon after it had become independent in 2011, the country was engulfed in another full-scale civil war, during which horrendous crimes were committed. Internationally, there were calls for criminal trials, and there is incredibly slow work to establish a hybrid court between South Sudan and the African Union. Speaking of avoidance strategies, in political science, there's even a word derived from Arabic for the Sudanese politics of delay, tajility. When interviewed, South Sudanese people indeed wanted accountability, but it would be a mistake to interpret that demand as only a demand for criminal accountability for international crimes. Research by Marijke Schomeres and Anouk Richterink shows that victims' call for accountability was at least as much a call for accountability for political failure to provide socio-economic justice. The same leadership that had led South Sudan to independence had, instead of realizing a peace dividend, immediately drawn them into a full-scale civil war because of their personal power struggles. Work on the hybrid court may have been slow, but that desired political accountability has been even slower. The same men are still in office. Legalized politics is just only one form of politics. Its logics can never be the full answer, just like economic logic of optimization can never provide the full answer. We still need other forms of politics, and it is therefore essential that the legal does not usurp the entire space of the political. Protecting that space cannot be an international court's responsibility. Once a matter is before an international court, it's unlikely that that court will say, you have brought this before us for a legal answer, but actually go to a different type of politics. But protecting the space for other forms of politics does warn against expansive interpretations of the logic of legal politics at the expense of other forms of politics. An example in the field of international criminal law concerns meetings between UN officials and persons who are the subject of arrest warrants or summonses issued by the ICC. The Rome Statute does not prohibit meetings with such people, but states parties will generally be under an obligation to execute the arrest warrants. The United Nations is not a state party, and the relationship agreement between the ICC and the UN provides that the two organizations shall cooperate, but it doesn't say anything on such meetings. However, the UN Secretary General has issued internal guidance on contacts with persons who are the subject of arrest warrants from the ICC. And the first principle of that guidance is that such contacts should be limited to those which are strictly required for carrying out the essential United Nations mandated activities. When in May 2023, the UN Secretary General's Special Representative for Children and Armed Conflict met with the Russian Federation's Commissioner on Children's Rights, for whom the ICC has issued an arrest warrant, legal commentators argued that the guidance had been violated. Now, and when last October the UN Secretary General met with the Russian president, another legal commentator went a step further, arguing that it was not just the internal guidance that had been violated, but also, and hereby, the UN-ICC relationship agreement, which is international law. So here you see international law being interpreted expansively to reduce the space for political meetings. Now, at a time in which many activists and many of us clamp to courts, hoping that they will do what politicians have failed to do, think about the climate change proceedings that are currently going on before the ICJ, other dimensions of the political require at least as much investment, no matter how gloomy the situation is, or indeed, precisely because the situation is so gloomy. Thank you.
Das war Weltrechtlich, der Podcast des ICWC. Abonniert unseren Podcast, um keine Folge zu verpassen. Weltrechtlich erscheint alle 2 Wochen und ist auf allen gängigen Plattformen verfügbar. Besucht uns auch auf Instagram, X und Co. und hinterlasst einen Kommentar, wie ihr die Folge fandet. Wir freuen uns über Bewertungen und Likes. Danke fürs Zuhören und bis zum nächsten Mal.